Thank you so much for having us. We are thrilled to be here and to help share some of the information that we learned. We got involved with this project through the Community Advocacy Clinic at the University of Tulsa through Professor Anna Carpenter. And one of the projects that she had set up for that semester in September of 2015 was the Oklahoma Access to Justice Commission. And the commission had requested us to kind of get access to justice essentially started in Oklahoma. They had the commission, and to help get a better idea of, in particular, I guess, limited scope representation and court navigator programs, and to really kind of talk about the current literature and the current research that is available on access to justice. So that's how we got involved with this. And what we're going to be presenting today is the report that the commission, that we presented for the commission, and this presentation that we gave to the commission in December of 2015. So again, I'm Joe Lang, and this is Bethany. Just recently graduated, and Bethany is about to graduate, I guess.
In December.
In December. So before I begin, I just want to kind of start anecdotally. Just the irony of the situation, just like it couldn't be any better. Coming in this morning to the Bar Center, we were here at about, I guess, 10 o'clock, and sitting in the lobby, somebody came up and asked me, are you a lawyer? And I said, well, as a matter of fact, I'm not. Soon to be, hopefully, but I'm not. And he said, well, is this where lawyers work? And I said, well, not exactly. I said, is there something I can help you with? Is there somewhere I can direct you to? And he said, I'm looking for a lawyer. I have a son. I want to see my son. So somebody that just kind of came off the street thinking that, hey, this is where lawyers go. I'm going to find a lawyer here. And he went to ask the reception desk, and there was nothing that was available to provide to this gentleman. And I went to the pamphlets, kind of looking for where can he find a lawyer for his specific issue. And there wasn't anything there. He had a little pamphlet that said, find a lawyer. And I asked him, do you have internet access? And he said, no. And I said, is there somewhere where you can find internet access? And he said, I think. So hopefully he went on his way, and hopefully he'll be able to find the help that he needs. But I think it kind of represents a little bit about what we had found in this project, and that is that when we initially started our work for the commission, we were talking to people that were interested in access to justice issues, as well as commission members in Oklahoma, and we heard a lot of ideas thrown out about interventions, things that we could do to help people. We have e-filing, we need fillable court forms, we need limited scope representation, and those are all part, but there is no one single solution. Just like for that gentleman that came in today, there's not one single way that we could have helped him in that specific situation. He didn't have internet access. We didn't have a written directory, and this is not exactly like a law firm, So it's a combination of things. And so what we did in our project was we took a step back, and we wanted to find out what are the underlying causes. We talk about access to justice, but what does that really mean? Trying to save it from being a buzzword, something that we talk about, but no one ever really questions, well, what is access to justice? What does that entail? And so part of our inquiry was discovering what are the underlying causes for a flood of pro se litigants in our courts, or in fact, as we found, the people that don't even go to court. How do we help these people get resolution for their legal problems? And in doing so, we kind of developed an understanding of a spectrum of legal needs, or of needs, I guess, that people encounter. That is, they first encounter a problem, we call a justice problem, something that could be resolved in the courts. And then as they have a justice problem, they want to seek resolution for that problem. And so in preparing, if they choose to go to court, they have to prepare to go to court. And there's a whole separate set of problems that they encounter trying to prepare to go to court. And then finally, when they get to court and litigating their claim, there's a whole set of problems. And so for each one of those steps in the process, there are interventions that can help, that we can do to help. So what we did, and what this presentation and our report is about, is a continuum of interventions, and it's a way of framing the conversation so that when we talk about access to justice, we talk about interventions in a really meaningful way. So it's a framework. The first part of our continuum is the point of conflict. That is when a person first experiences a justice problem. So the vast majority of people, actually, they don't go to lawyers or courts for assistance. And it's actually because people, they don't understand their problems to be legal, and only 17% said that money was the reason why they didn't seek out the help of an attorney. So what this is indicating is that there is a vast population of people. When we talk about access to justice, I think it's really easy to get caught into a trap of talking about the people that we encounter as lawyers, law students, judges, people that we see in court that don't have an attorney, don't know what they're doing. But in fact, there are just a vast number of people that don't even come, that we don't even see. And that's part of the access to justice problem. And only a very small segment say that the reason why they don't encounter the legal system is because of money. So it's about reaching out to people when they first encounter a problem and giving them access to information about how to resolve those problems, be it through the legal system or an alternative method. But it's about giving them information to manage those problems. And two of the specific interventions that we focused on were co-located services and internet outreach. So just talk briefly about co-located services in particular. That is when an attorney goes to a location that people frequently experience a problem, and they are there to kind of, at that very point of conflict when they first encounter that problem, to give them information. We see it's actually it's a new and developing type of practice that we see in medical legal partnerships is actually the most common one. So a lot of people, they don't, if they have asthma, for example, cockroach infestation can exacerbate their condition. And having an attorney on staff at a hospital, a doctor can, if this person is in poor housing conditions, this doctor can refer the patient as part of their treatment plan to the attorney to improve their housing conditions, which will therefore enhance their asthma condition. So when we are engaging the community, and not just in the law firm, we can give people what's called trustworthy, targeted, and timely information, giving them those three things at the source. And that helps bring people in to the legal system that might not recognize their problem to be legal.
And preparing for court. Stage 2 of the continuum concerns people who identify their problem to be legal but don't have the necessary resources to resolve their legal issue and turn to the court seeking resolution. This is a widespread problem, as there's at least one self-represented litigant in 70 to 90% of cases. A major barrier for pro se litigants is that they often don't understand how to utilize substantive law or court procedures, which leaves them not seeking or achieving really meaningful resolution. Two interventions that we looked into specifically are simplified court forms and court form instructions. A number of jurisdictions have begun simplifying their court forms and creating them in a more clear, understandable way, such as fill-in-the-blank forms. And also, they have begun using, a number of jurisdictions have begun utilizing court form instructions, which just help to guide litigants in preparing forms and filing them with the court. We reached out to jurisdictions for what they were experiencing when these things were being done, and they actually said that they were experiencing an increase in judicial efficiency as litigants were able to fill out their forms correctly, and judges were actually able to better manage their caseload, and it even eased pressure on court clerks. Moving forward to stage 3 of the continuum. The problem concerns people that go to the court without the assistance of an attorney. In a perfect world, everyone going to court would have an advocate, but due to resource restrictions, that's just not a realistic resolution at this point. However, stage 3 really focuses on making the courtroom, the courthouse, more accommodating to self-represented litigants. The first thing we looked into, the commission called us to look into, was court navigator programs. A court navigator is a person who assists self-represented litigants through a legal court-based service. The legal assistance provided by a court navigator is actually limited to legal information and emotional support. So unlike attorneys, they don't actually provide legal advice. They are not licensed. They actually just go through a significant amount of training and have a significant oversight. And the second thing that we looked into was limited scope representation. Limited scope representation is when an attorney breaks down the tasks related to a client's legal matter and only provides representation for a portion of the client's legal needs. Limited scope representation is often referred to as a la carte representation because it allows the attorney and the client to choose what the representation will entail, so whatever is most fitting for that client's specific needs. The most 3 common limited scope representation forms are document preparation, representation in court, and advice and counsel. Limited scope representation does require a clear understanding between the attorney and the client of what the representation will entail, and such as when it will formally end. It's more appropriate in some forums than others. Document-heavy, transaction-based are more appropriate for limited scope representation, such as family law, business law, immigration. But limited scope representation is not as fitting for areas of law that require ongoing legal representation, such as criminal law or complex custody disputes. We realize that there have been some concerns about whether a limited scope representation can be ethically practiced in Oklahoma under the current rules of professional conduct. And in 2008, Oklahoma adopted Model Rule 1.2c, which permits attorneys to practice limited scope representation as long as the representation is reasonable under the circumstances. And it also adopted 6.5, permitting nonprofit, pro bono, and court-based volunteers to practice limited scope representation. And throughout the course of our research, we reached out to experts in the access to justice community, and we performed a cross-jurisdictional analysis to see what other states were doing. And it was echoed by the experts that they were seeing limited scope representation practiced in their states, and they were not experiencing ethical issues arising. They were seeing a lot of success with it. Judges were happy with it. Instead of it flooding the court docket, it was actually making the judicial process run smoothly. And these states were practicing with the Model Rule 1.2c, just like Oklahoma has adopted. For example, we reached out to Massachusetts, which is very progressive in the access to justice community, and we also reached out to Texas, which has a more similar political climate to Oklahoma. And both experts in those states said that they were seeing limited scope practiced successfully, and we're really seeing that self-represented litigants were finding it very helpful and favored it, and as well as the judges.
So included, we sent Michael Speck the report that we presented or that we gave to the commission. So for copies of this, you can see Michael.
I'll email it out to the full committee.
We have it in PDF and in the print version,
Right.
so
Right.
PDF might be more easier.
Right.
Easier.
And it sounds like since we gave this report, there's been movement already, especially with simplified court forms, which is incredible to see the willing attitude of the state, the people that are interested in this in the state, to make this happen, to make some of these things happen. And again, I think to reiterate, the real thing that I think we want to encourage is a way to talk about access to justice. To not just talk about it as interventions, but to talk about it in respect to solving problems. That there are specific problems that each intervention relates to in a spectrum of needs. And so that was our goal, and we hope that we were able to share that with you today.
Thanks.